Can everybody hear me okay? Good, okay. Well, when Kelly contacted me last spring to see if I would be available and willing to present at this particular conference, I was flattered, and I thought, gosh, that sounds good. And then she suggested that the materials that I cover would be an update on case law. I was less flattered. And then she told me at some point that I would be presenting at about 3:15 in the afternoon on a Friday. Kelly? So anyway, I'm hopeful that the materials themselves do a pretty good job of presenting what cases have come down since the last regional conference. So the title in the materials says from 2009 through 2010. We're really looking at a time period from August 2009 through as recent as earlier this month. Since you have the materials, and I thought there really isn't a whole lot. I am a practitioner. I don't proclaim myself to be an expert. I'm loosening my tie because I don't want anyone to have a sense that I'm anything more than one of you guys. I'm a colleague. If you have questions about any of the materials, I'll answer what I can. I'm hopeful that there may be some feedback in the audience or input from those who know as much or more than I do about any of the given cases. But since you have the materials, I just thought, you've got those. I think I'm going to cover a different topic. And Kelly, I hope this is okay, but you kind of put me on the spot. So you've got those materials. Instead of the case law update, this afternoon I'm going to talk a little bit about the EPA influences in the arena of aquatic pesticides. Okay, see, there are worse things than case law updates. I'm going to give you the Cliff Notes version of what cases have come down from the Court of Appeals or the Supreme Court over the past 12 months. At the beginning of the materials, you'll note that there are two different websites that I've identified. I used both of those websites pretty extensively in compiling the materials that I have. And I would, in particular, Sarah was here earlier today and presented and really did a nice job yesterday with me, providing me with the website information. And if you haven't gone to the Nebraska Appellate website, you should. It's real helpful, not only for court opinions, but also for legislative updates and things that are going on. So I presume that everybody here utilizes the Through the Eyes website. Again, that's another good source. If you go to the Through the Eyes website and you haven't doing any type of case law search, they have a search engine where you can put just words in, and it'll take you to a particular case. So lawyer, non-lawyers, use that website. I think it's real friendly, user-friendly. If I can use it, you can use it. Okay. First case, in the interest of Leslie S. As we go through this, too, I'll show you just how difficult some of these names are. This case was an ICWA case, transfer from the tribunal, or the idea was there was going to be a transfer to the tribunal court. The burden of proof falls on the non-moving party if there is a motion to transfer a case to a tribunal court. So that's what I took from that particular case. In this matter, the juvenile court judge denied the transfer motion, finding good cause had been shown to prevent the transfer because the issue had been previously litigated, and overruled because the juvenile court would continue to have jurisdiction over truancy and delinquency in non-ICWA case, even though there was a 3A case that was presented for transfer. So the court already had some jurisdiction over some of the other issues, and held that the party opposing a transfer of jurisdiction to a tribunal court has the burden of showing that good cause does not exist to allow the transfer. Next case is in the interest of Lewis S. This is another ICWA case. Now, this was a case, after I looked at it, I thought, I didn't realize if you have an ICWA case that involves a termination of parental rights, in addition to the two-prong test of one of the 11 bases plus best interests, there are two additional elements that have to be proven in order for there to be a termination of parental rights in an ICWA case. Those two additional elements include that, quote, active efforts have been made to prevent the breakup of the Indian family and that these efforts have proven unsuccessful. And then the second of the additional elements is that the continued custody of the child by the parent is likely to result in serious emotional or physical damage to the child. References on the statutory references for those additional elements are Chapter 43, 1505, subparagraph 4, and subparagraph 6. Next case, in the interest of Joshua T., I'm on page 4. Issues here were abandonment, and there were some, in this matter, the Court of Appeals reversed the termination of parental rights that was based on abandonment when the mother had had no contact with the child for a period of 9 months and was incarcerated. But there was little to no other evidence of the mother's intent to abandon or information such as the length of her sentence. So this was a case that I read to mean that there has to be a good record made. If you're looking to terminate parental rights, you may want to make as solid of a record as you possibly can. The court noted in that case, a case might admitted at the dispositional hearing, but not reintroduced or judicially noticed at the termination trial, was problematic, and that was cited as part of the basis for overturning the termination of parental rights. Next case, in the interest of Jade S., and I think I misquoted you there. This would be page 2 of the materials that I've provided you. The issue here was relinquishment and making a record of its validity. This was a case where the mother who had relinquished, and the relinquishment had been accepted at the trial court level, appealed and indicated that her relinquishment was not provided voluntarily. Court of Appeals found that the assertions could not be resolved, the assertions by the biological mother that she had been either forced or had made the relinquishment involuntarily, could not be resolved without an evidentiary hearing, and so the Court of Appeals reversed and remanded the case with direction. Held that the record was insufficient to show that the juvenile court was able to rule on the mother's motion because the court ruled on the motion at a review hearing prior to the scheduled hearing on the motion that the mother had filed, indicating that the relinquishment was coerced. Next case, page 3, in the interest of Ethan M. This is a case I think that is noteworthy because of the issue of custody. And I'm not sure, there's a lot of folks from the 10th Judicial District here. Outside of the 10th Judicial District, I imagine it's the same situation oftentimes in these juvenile cases. Do you need to seek a modification of a custody order that was entered at the district court level prior to there being some sort of closure or conclusion to the juvenile case? In this particular case, the appellate court identified that the same procedure has to take place within the juvenile court once it has taken jurisdiction over the issue of custody as it would have if it were at the district court level. So custody modifications proceeding normally conducted at the district court level, which means a complaint to modify custody is filed. Court holds a custody modification proceeding, and the moving party must show a material change in circumstances and that the modification is in the child's best interest. So there is nothing surprising about that, but they delineate it in that particular case. Next case, in the interest of Alan G. This is the point in time that I ask everyone to turn your cell phones on. Because people move really quick when their phone rings in a setting like this, so we'll just keep everybody awake. In the interest of Alan G. Here the court noted that the guardian ad litem who was appointed in the case does not have to be present for the termination of parental rights hearing. The parents had appealed on the issue, or at least one of the appeal issues was that the guardian ad litem was not present for the TPR hearing. The appellate court determined that that's not a necessary requirement for purposes of terminating parental rights. That goes with they didn't make comment on whether or not the guardian ad litem had met his or her responsibilities within the case, but the issue was, do they have to be present or not? And the court said no. Another issue that came up on that appeal was that one of the parents had not, according to the Court of Appeals, been given an opportunity to show his ability to be fit and provide for the child. And it noted the father, Candy's parental rights on the basis of best interest should not be taken away. The Court of Appeals stated Candy's opportunities for compliance with the case plan were limited. His participation in the juvenile proceedings was voluntary, and the state did not file a petition alleging any wrongdoing on Candy's part, Dad's part, prior to the filing of the motion to terminate his parental rights. This was a scenario where Dad was not named in the petition. He was a non-custodial parent. They proceeded through the adjudication and dispositional stages. Dad was in and out of that process. They ended up filing to terminate parental rights on both biological parents. Dad got involved in the case plan toward the conclusion prior to the termination petition, and the Court of Appeals determined that Dad didn't have enough time to show whether he could or could not do it. So they reversed the decision on Dad. Next case, in the interest of Nylang. And this is the bottom of page 3 of your materials. Not too much to note in this case that I could find. This was a termination hearing that was upheld based on substantial and continuous or repeated neglect from both parents. This was a case where the parents had moved outside of the jurisdiction of the court, had kept pretty minimal contact with the kids. Next case, page 4, in the interest of Hope L. Interesting case. This is a case that probably was newsworthy. I don't remember reading anything about it, but some of you may be familiar with it. A child, the parental rights were terminated of a child's parents after there was a determination of Munchausen syndrome by proxy. 3 kids in the home. One of the children had ended up in the hospital. The parents had continuously attempted to remove the feeding tube from the child. All of the kids from the home were placed in protective custody, and ultimately there was a determination that parental rights should be terminated. There was an interesting note in this case too, just as an aside. The court had rejected the mother's argument that the guardian ad litem should have been removed from the case after the guardian ad litem had submitted some type of a report or request at her sentencing in the criminal case. So for all the times you hear those guardian ad litems not getting involved enough, in this situation the guardian ad litem did too much according to that mother. So next case, in the interest of Marcella B. and Juan S. This raised an issue that was in a couple of the cases that I identified. And that is that juvenile in-chambers testimony can and may, if not probably, will be declined, and that's not a final appealable order. In this case, there was a motion made by the guardian ad litem to have an in-camera or in-chambers interview of the child versus requiring that the juvenile testify in the pending termination trial. The Court of Appeals held that children do not have a substantial right to testify in chambers. Therefore, the juvenile court's overruling of the motion for an in-chambers testimony was not a final appealable order. The appellate court did not have jurisdiction to hear the appeal. They went on to say, though, that there was no precedent recognizing a constitutional right for a victim to testify against the accused. Thus, the appellate court concluded that the child had no constitutional right to testify in juvenile proceedings. The Court of Appeals acknowledged that there are safeguards in place to do so. The juvenile court has a responsibility to protect the best interest of the child. I think that puts the juvenile court judge in a heck of a position. You're supposed to, the court, have an obligation to protect the best interest of the child, but that does not necessarily override the substantial right that an accused has to confront their accuser. So it's an important case, I think. And there's a second case that's noted in the materials that cites this case, and the bottom line is there's no guarantee if you make a request of your trial court to prevent a child from testifying in open court and instead having some type of in-chambers testimony or interview that you're going to be allowed to have that. I see lots of people wincing in the audience on that. Questions about that? It's unsettling, I think. I'll be interested to see how that case affects things not only at the trial level, but at some point if that's not argued further.
Mike, I know of a situation in Hall County where similar situation, and the court had the ability to use a closed circuit TV situation. So the parents who were accused of wrongdoing against the children could still hear and see with their attorneys the children testifying, but the children didn't have to testify face to face in front of the parents. So that was an option for the judge in Hall County to still protect the kids, but allow the parents their right basically to confront the witnesses against them. So I thought that was a pretty fair resolution.
Yeah. Everybody hear what Jay had to say about that?
A good option. Did the parents appeal that decision then of not being face to face?
Well, the case has been appealed, but I don't know if they appealed that particular. That was at the adjudication phase, so it wasn't at the termination.
Oh.
And I know the adjudication was appealed.
But Sam just asked, how did they handle the cross-examination of the kids if they did it in camera like that?
The attorneys then went down after direct examination and conducted cross-examination, and the clients were able to continue watching, and then they took a break. Attorneys went back, talked to the clients, talked to the clients, see if there's anything else that they wanted to, issues raised or not, and they went back down. And during the whole time, they had the closed circuit TVs, but also then had court reporters certainly taking all the testimony.
John, did you have a comment?
Yeah, I was just going to ask if the case disapproved of in-camera testimony, or if it simply said that it's not an appealable issue and we're not going, whatever the judge decides in a particular case is probably not going to be disturbed.
Yeah, the determination was that it wasn't an final appealable order. So but they went on to make comment about the substantial right of the accused. Thank you. And so, I think that lends itself to further argument or appeal. Thank you for the comments. Keep them up. Anyway. Okay. Let's see. Next case is the only adoption case that I identified and provided in the materials. And Judge Ott, I thought of you. This particular case ultimately resulted in the adoption being vacated. And for those of us who practice in the 10th Judicial District, Judge Ott has created what I refer to as a laundry list of all the necessary things that must be done prior to submitting a petition for adoption, including all the exhibits and all, making sure you cross all your T's and dot all your I's. And I don't know how many times I've said, geez, this is really a pain in the tail. But this particular case reminded me that there are reasons for this. And what happened here is there was a father who had what the court determined to be a familiar relationship with his child. And because of that, there was required to provide his consent for the adoption to take place. Now, the father had essentially indicated that he didn't want to have a relationship, but there had been a child support order that had been entered, and so ultimately, by the parties who presented the adoption to the court not obtaining the consent from the father under the circumstances, the adoption was determined to not be valid and was vacated. So make sure you cross those T's and dot those I's, everybody. Next case, in the interest of chance, that's an abandonment case. Interesting case, only from the standpoint I thought that the father was African American, the mother was Caucasian, the child was born, quote, white, blue eyes, red hair. So Dad determined that he couldn't be his when genetically it turned out that in fact the child was his. So always good to have some follow through. There was something else the court noted in this, and I thought this was a nice quote that came from the Court of Appeals. I'm sorry, this came from the Supreme Court. The court stated that, quote, the obligations of parenthood cannot be set aside that easily, based on nothing more than mere physical appearance or unconfirmed suspicions. The court found that Andrew, the father, abandoned Chance, the child, and that he intentionally withheld from Chance without just cause or excuse his presence, care, love, protection, maintenance, and opportunity for the display of parental affection. Next case in your materials is page 7, in the interest of Damien and Alexandria. This is a case, I think, a scenario that comes up pretty regularly for us. Thank you. Domestic violence background. The mother chooses partner over children coming back into the home, and ultimately, in this particular matter, the appellate court upheld the termination of parental rights. I'm sure lots of other factors that worked into that, but 24 months passed, and that was enough for the Court of Appeals to say she had her chance. Next case, in the interest of Manual C, what I took from this case was interesting. Isolated incident of abuse can be sufficient for an adjudication. So I've approached cases most often thinking, okay, if there's not some sort of pattern of abuse, then it's going to be a pretty tough case to adjudicate. The appellate court in this case, in which a father used an electric wire to beat on his 16-year-old son, was one incident and was sufficient for purposes of finding by preponderance of the evidence that there was abuse and neglect. In the interest of press to know, it's a case where the court overturned the termination of parental rights because a guardian ad litem had not been appointed for a parent where there were allegations of mental incapacity by the parent. In the interest of Christian, overturned or reversed reversed a termination of parental rights because there was a due process violation. The state had utilized information and evidence indicating that the parent had mental incapacity or mental illness that contributed to inability to properly parent, but the state had failed to include in its petition that it was going to pursue those allegations at the time of trial. So due process says if you file your petition, you live by what's in the petition, and if you don't include things that you intend to bring at the time of trial, then you're not going to be able to use them. Okay, I'm going to skip a little bit because I've just got a few more minutes. I hope everybody's as happy about that as I am. Nobody's phone has gone off yet. Let's see, I'm going to take you to the bottom of page 9 of your materials, in the interest of Rena G. in this case, parental rights were terminated, or were not terminated at the time of trial, or at the appellate levels. And the issue was that just because a parent is unfit in the past does not necessarily mean that that equivocates to them being currently unfit. So, Court of Appeals noted that even though the father had a history which included incidents of violence, incarceration, homelessness, and drug and alcohol abuse, since he learned that the child was no longer living with her mother, the father made an effort to refrain from criminal activity, from drugs and alcohol, and had secured a home for himself with stable employment. If I'm representing the parents in any particular case, I cite this case to them and tell them, this is the Jimmy Valvano case. Don't ever give up. You know, there's a chance. Okay, I've got just a couple more minutes. I started this by saying I'm not going to be able to answer many questions that you can't answer yourself, or maybe somebody in the audience can answer. And so I open it up to a couple questions if anybody has a question or a comment. But as soon as you ask that question, I'm going to turn to the audience and say, okay, what do you guys think? So, questions, comments, concerns? I will tell you that the other than cutting and pasting and making sure that the grammar seemed correct and the punctuation seemed correct and the typos were taken care of, hopefully most of them. These materials came directly from those two websites that are included at the beginning of your materials. And so if I send you home with anything, I think this is pretty comprehensive of case law that's come down in the past year involving juvenile cases. But really it's at your fingertips. If you can get to those internet sites on any particular issue, I promise you're going to be able to find a case with relative ease. So, thanks for your, oh, John?
I was just going to ask one question.
Nope, sorry, time's up.
Through all these, how many of them did you think really turn on fact specific, that because it's de novo on the record that they get to make up their own mind?
I have no idea.
Okay.
Yeah, you know, I don't know. I could speculate and say I think probably the majority of them were reviewed that way. There was one case in here, and it's in the materials. I didn't discuss it. There was a 2-to-1 split, and my read on that case, it was Judge Severs and Judge Inabati who agreed, and then Judge Caselaw dissented, and I read that to mean that the two judges who ruled that the termination of parental rights be overturned, it was a situation where there was one incident of a father being arrested with a small amount of cocaine, and my read on it was there was not a very good record made of the other factors besides that small amount of cocaine. And so I think the two judges who ultimately were the majority on that decided there just isn't enough evidence on the record that's going to support this. I think Judge Caselaw looked at it and said, this is a horrible situation. We got to figure out a way to terminate parental rights in this matter. So I think they take a hard look at the facts in every case, and my guess is the majority of the cases, it has a significant bearing. Okay, well, my hope is to keep everybody awake.